All right, we're still on the record in 2024 CR 3533, State versus Alex Neosk. We're still on the oath, and defense is still your witness.
Thank you, Judge. Oh, okay. I thought she was asking me to wait.
It's your witness.
Yes, ma'am. Ms. Wise, in the aftermath of the incident, so since the day of the incident, you have not seen Alex, correct?
Except on Friday, he got some of his belongings. I have not seen him.
Okay. There's really not been any communication, any contact or anything like that. And this was in February the 8th, correct?
Since
Okay. In the immediate aftermath of the incident, for about a week to 10 days, do you recall texting Alex? Yeah, for about a week to 10 days in the immediate aftermath of February 8th, do you recall texting Alex?
Yes, sir.
And for about a week to 10 days, would you agree with me that it was a one-way texting conversation? You kept texting Alex over and over and over, and Alex just didn't respond.
Objection, hearsay.
Sustained.
Okay. You continued to text Alex. Okay. I want to talk to you about April the 7th. That is a day that you had come down to the DA's office to visit with them about the incident and also to visit with them about some of the details you're providing. Do you remember that day? Yes.
Yes.
Do you remember who you met with?
So Sarah, there's somebody else I've spoken with. That's the problem here too. There's 3 women.
Okay, do you remember how many people were there?
3 women.
Okay. And the purpose of that visit was to go over the incident with you, correct?
Yes.
And they also were asking you questions, maybe seeking information they didn't already have or details they didn't already know about, and they were asking you. Do you recall that?
Yes.
Now, we've already talked about the SD card. I believe that you testified that you remember the SD card coming up in that conversation, and you were quite clear with them. The only reason there's not a video recording was because there was no SD card.
Objection, asked and answered.
Sustained.
Okay. Do you recall there being a discussion about the SD card?
Objection, asked and answered.
Overruled.
Yeah.
Yes.
You can answer.
I said that there was a possibility that I would have to get to a tree or something, but I'm so long with that camera and the SD card specifically in that bedroom camera, there has not been one since January 1st, as I had stated previously.
All right. With regard to any potential audio recordings, do you recall that discussion happening?
With SD cards only carrying so much storage, trying to go back months prior, it overwrites itself.
Okay. And I want to be very, very specific. And my very, very specific question is this, Ms. Wise. Did you tell the prosecutors and the advocate on April the 7th, when you were meeting with them about the details of this incident, that you had an audio recording of the incident?
Objection, asked and answered.
That'll be overruled.
To say yes, it was a possibility. I will check it. I was not able to check it. So.
Okay, so your memory is you told the prosecutors you might have an audio recording.
Yes.
Okay. With regard to these videos that we're talking about, how many cameras were in your apartment that could have recorded or gathered audio or visual information?
Well, I would be able to review it going back. It would be the living room back. So First, if we're on our bedroom, you cannot pull up any previous storage on that one. You have to look at it from a live view of the baby monitor.
Okay. There are 2 cameras in your apartment, correct?
Yes, sir.
And the cameras are linked to an app, correct?
Yes, sir.
And the only person that had the app or access to the app is you.
Yes, sir.
And so, sort of like a Ring camera. Now, these are not Ring cameras, but sort of like a Ring camera. They send videos to your phone, correct?
If I try to like review it, nothing gets sent to me. I can pull back up though.
Right.
After so much time though, you cannot. It's the SD card is the limited space.
Understood. And the person that has complete control and access to all of the content, audio or video, is you.
Yes, sir.
All right. Alex didn't have any control of any of that, did he?
No, he never asked for the loan.
Okay, Your Honor, for now, that's all the questions I have. I'll pass the witness.
Just a few more questions, Your Honor. Ms. White, why are we here today?
Alex punched me in the face and that was a violation of his building.
Okay, can you identify, is the defendant here present in this courtroom today?
This is,
Can you please point him out by clothing?
he's wearing the striped, collar polo at the table, that's position.
Okay, thank you. Let the record reflect that the complainant has recognized the defendant. Ms. Weiss, do you still fear the defendant? And why is it important to you that the court or the defendant is held accountable for what he did?
Judge, I'm going to object. This is not relevant.
Sustained.
Okay. No more further questions, Your Honor.
Any further
No,
questions?
no additional questions, Judge.
Is this witness excused?
Yes, Your Honor.
I mean, I would say for now, if we could keep her around, Judge, I might have to recall her. I'm
All right,
sorry.
if you'll keep the witness available today for recall. State, call your next witness.
With the state rests, Your Honor.
Defense, any witnesses?
Yes, Judge. Judge, can we approach briefly?
Yes.
So, after hearing some of the direct testimony, I would need to be calling her as a witness. A brief conversation about that. My understanding is that her advocate, Sarah, was also there, and she informed me that I could utilize her if I needed to call her.
Who do you want to call?
It honestly does not matter to me.
No, I mean,
The advocate,
whoever you want to call.
You have to go to the proper channels of subpoenaing.
This is a rebuttal witness, Judge. This is
No, who do you want to call?
Sarah.
Who is the Sarah person?
Yeah, look.
All right, can you have Sarah come down?
Well, Judge, I was here wanted that she be made available to me as well.
Proper channels still to be followed. Your Honor, he needs to subpoena Sarah if he wants her down in court.
All right, did y'all tell him that she would be available?
Yes.
Not a party to that
All right.
conversation.
Have Sarah come down to court. And if somebody from the appellate section wants to file a motion that she should not be allowed to testify, then y'all can do that. But tell Sarah she needs to come down.
I'm texting right now.
All right, thank you. Anyone else you want to call other than Sarah? Did you want to call Ms. Jones as well?
I don't believe that I will have to, Judge, so no.
And where is Ms. Jones?
I believe she's upstairs too.
Have Ms. Jones come down as well.
Yes, Your Honor, texting them both.
Let it go.
All right, and then we're going to take a short recess from this and I'm going to take up other matters.
Yes, Judge.
Thank you. Eddie Baldwin.
Yeah.
All right, and after Eddie Baldwin, then I'll take up the matters on the parties who are here for trial.
Hello, Your Honor.
Hello, how are you doing?
I'm doing good.
Wait a minute, let me put on my glasses. Is that SpongeBob?
Yes, it is.
Oh, there's a rumor, and I think the facts will bear this out, that the Krabby Patties are made from crabs. Oh. And that's why you don't see any crabs in SpongeBob's world, in Bikini Bottom. Have you ever seen a crab in Bikini Bottom? Except for the crab patties?
Mr. Krabs. Mr. Krabs.
Mr. Krabs is
That's
killing
what he guards that recipe.
He does.
You got
That's right.
something there.
What?
That's a really.
Sorry. All evidence points towards that. And don't get me started with the squirrel. I mean, everybody just was fine with her putting on her helmet going down there. But okay. I like SpongeBob.
Thank you.
But now that song is going to be in my head. All right, the court is calling 2026 CR 0000656-02, State versus Eddie Baldwin. Can I have parties announced?
Lauren Espinoza for the state.
And Valerie Headland for Mr. Baldwin.
I'm so sorry. You're going to have to take that to the court. Yeah.
Oh, yeah.
And are you Mr. Baldwin?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Baldwin, did you review the application for community supervision with your attorney? Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading?
Yes.
State, are you proceeding on the indictment as presented?
I do believe so, Judge, yes.
Mr. Baldwin, did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places? All right, to charge with the offense of robbery, that's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Baldwin, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 4 years in the prison. There's a $1,000 fine probated. The state recommends community supervision. They're taking in consideration 2025 CC 016045. Did you understand that to be your plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that you're waiving your right to appeal, the only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, any such motions?
No.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be 100 hours of community service restitution, no contact with Judy Apolinar or any Cricket Wireless in Bear County, MRT, and the felony theft course. Did you understand those are recommendations from the state?
Yes,
And
ma'am.
the court does not have to follow those recommendations.
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contact.
State, any evidence?
Yes, Your Honor. State offers State's Exhibit 1 in all attachments.
No objection.
All right, state, you may be excused.
Thank you.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, please.
Anything you wish to say on behalf of your client?
No, Judge, he was in custody for quite a few minutes
Yes,
before you pointed out. So I think he's had plenty of time to reflect, and I think he's gonna do well on probation.
Why did you do this?
I was on drugs. Yes,
Okay.
ma'am.
So, are you living with someone? Do you live by yourself?
I live with my mom.
Okay. Do you have any children?
I got one, a
Right.
son. Yes,
And
ma'am. He's
age?
5 years old.
Okay. How far did you go in school?
I made it to the 10th grade.
Okay. Have you obtained a GED or
Yeah,
anything?
ma'am.
When's the last time you had employment?
In a courtroom proceeding for State versus Alex Neosk, the defense questioned the complainant about her lack of contact with the defendant after the February 8th incident, including attempts to text him and her April 7th meeting with prosecutors, where she discussed possible audio recordings and confirmed there was no video due to the absence of an SD card. She acknowledged having sole control over the apartment's camera system. After brief redirect questioning identifying the defendant and addressing fear, with objections limiting scope, the witness was excused but kept available for recall, and the court discussed calling additional witnesses, including an advocate named Sarah. The session then shifted to a separate case, State versus Baldwin, where the defendant entered a no-contest plea to a robbery charge, acknowledged his rights and plea terms, and was found guilty based on submitted evidence, with sentencing considerations including community supervision and personal background factors such as drug use, employment history, and family situation.